number 48, which is the people of the state of New York versus Matthew Kuzdzal. I hope I am pronouncing that correctly.
To my knowledge, that's about as close as you can get, Your Honor. Good afternoon, Matthew Powers on behalf of the people. If I could, with the court's indulgence, request 1 minute for rebuttal.
You may, sir.
Thank you very much. Where a trial court finds a third-party allegation of relating to jurors' qualifications to be incredible, we're asking this court to hold that it does not abuse its discretion when it dispenses with the need for a Buford inquiry.
So how do we know from this record that such a finding was made, either by the trial court or the appellate division in exercising its factual review power, which of course we don't have?
Well, I'll start with the trial court, Your Honor. I think the best evidence that that's what it in fact did was the fact that the prosecutor specifically requested the court to rule on the threshold issue of credibility, and in immediate response to that, the trial court said that it did not think that the inquiry was necessary or appropriate based on what it had heard. And of course, what it had heard just moments ago was the account of Brandy Carner, the third party.
But how do you know that that means I find her incredible, as opposed to it's credible, but it doesn't rise to the level of something that warrants legally having to make the inquiry? That's the problem I'm having in terms of reading this record. I mean, obviously, if the judge had said, I find Ms. X incredible, we wouldn't be here.
Mm-hmm. Well, I think the best I can do, Your Honor, is to tell you that that it was made in direct response to the request to rule on the issue of credibility. And certainly one of the problems that the appellate division had with what the trial court did was in finding that its, whatever its determination was, that it was conclusory. And one of the remedies I propose for this court is if you agree, if you have that same problem, that it might make more sense to remit the matter for the trial court to state in no uncertain terms why exactly it did what it did.
So what was it that made her so incredible? How do you explain that?
I think that the three best sources of evidence for such a finding, and of course I can't comment on anything regarding her demeanor, there's no record of that, but it's possible that that played in the trial court's mind. But what we can refer to as far as the record is concerned is the very real potential for bias on her part, specifically her relationship with the defendant. She was described by counsel as his girlfriend. She declined to acknowledge that relationship, but did admit that she was a lifelong friend. So I think there's very strong evidence that she was biased in favor of defendant. The second example is her behavior. She admitted that she was thrown out of court the day before, which I think suggests a lack of regard for the proceedings. And the third example is the incoherence of her timeline regarding the allegation. She said at one point that it came on a break and specifically used the number 15-minute break. And then moments later, when confronted with the fact that there was no break, said, oh, no, it was after court, and seemed to adopt whatever the truth was.
Well, let's assume all of that. Let's assume that makes some threshold, reaches some threshold about the credibility. Given the serious nature of what she claims she overheard, referring to the defendant as scumbag and laughing and mocking him and so forth, she did mention that she was with someone else. Why wouldn't the judge at least call the other witness?
I think a couple reasons, Your Honor. And the first is that claim is unpreserved for this court's review. There was never a request by defense counsel.
Let me give you a hypothetical.
Sure.
Let's move beyond the preservation question. What if you have the same scenario? You have someone, we're not talking about jurors, we're talking about others who claim they've overheard or observed the jurors do something that perhaps falls within as a matter of law, suggesting that they're grossly unqualified. And the judge has some concerns about whether or not the judge is willing to believe that witness. But they say, I was with someone else, I was with 5 other people, they heard the same thing, they saw the same thing. Why not call someone else? Given the serious nature.
Sure.
Right?
Certainly, if it had been asked for, I think it would have been the appropriate remedy. The problem with doing it here is that Ms. Carner never named her friend, and there was no indication on this record that her friend was even present the day Ms. Carner made her allegation. So I don't know that it would have been possible, even if it had been preserved.
What's the duty and obligation of the court in these types of Buford scenarios, when it's not a juror, right?
When the allegation is coming from a third
Yes,
party? I
correct.
think it's a little bit different. Very often, we see the information coming from a juror note, like we saw in this court's decision in Mejias, or from some maybe more reliable source, like a court officer or the court or one of the attorneys. And I think there's a pretty good reason to credit the information when it comes from one of those sources, particularly where it comes from a note, because it's from the juror themselves. But when it comes from a third party, I would refer to the Third Department's decision in Matias, where there was an inquiry of a third party, but not of the jurors. And I think the court should consider both the credibility of the allegation to the extent that it can exhaust or satisfy its curiosity regarding the credibility.
My problem, or my difficulty with that is, of course, that talking just practically, who's likely to have been in that courtroom if not someone who's somehow connected to the case? It's true, as, for example, today, we may have people just observing the case or totally unconnected to it. But the nature of it is you may have people who have some connection in the room and may very well be the people who overhear. I'm having some difficulty discounting credibility merely because they have some connection without the judge doing what they would do in what you seem to at least not fully concede, suggest might be appropriate if it's something that comes from a juror or from a court officer or someone else who may not be so connected to the case in the obvious way of suggesting bias.
Well, I guess bias is, as I mentioned, only one of the reasons I think the court was justified in arriving at this conclusion. And there is a very real possibility that anyone who is an observer of a court proceeding is likely to have, to
I
use
take it your position is if a juror sent out a note saying another juror called the defendant scumbag, you would agree under those circumstances Buford requires the inquiry of that other juror?
I guess I would counsel 100 times out of 100 to conduct the inquiry in that instance, yes.
Of who? Of the juror who passed the note, or the juror whom the juror who passed the note is speaking?
I think there's at least some room for discretion in there, Your Honor. We're concerned with probing and tactful inquiries, and that means we care about both the truth, but also not being overly intrusive upon the jurors.
Counsel, what if the other juror or a third-party witness, what they said that they heard the juror say is, after hearing all of that proof, I really think that defendant is a scumbag. Okay, does that indicate, is that the kind of bias that Buford is directed at, or does it have to be a pre-existing bias? In other words, if somebody forms an opinion about the defendant based upon the evidence that they've heard, then aren't we just talking about possibly entering into deliberations prematurely, and we obviously have case law about that.
That's certainly our position, Your Honor. The appellate division took the position that the statement reflected bias, and our counter to that, of course, is that it was not biased. There was nothing on the face.
So what's the obligation of the court? Can the court make that determination without conducting a Buford hearing? That's really just my question.
I think we ought to try at least to tether ourselves to what the allegation is. So if, and I see my time's out, may I finish answering?
Yes,
Thank you,
please.
Your Honor. If the juror had said something or was alleged to have said something like, I always knew he was a scumbag, which means that they're carrying that belief with them into the trial, then I think we're squarely in bias territory, and you have to do the inquiry. But considering both the statement on its face, which is just Matthew's a scumbag, and the timing of the statement, it was made after the conclusion of all proof. I think looking at that, there isn't necessarily a reason to conclude that it was in fact a pre-existing belief, and
So
we're
the
more.
question then would be, was it an abuse of discretion? Is that,
If all we're talking about is premature deliberations, then under Mejias, no, Your Honor. It's quite the contrary.
Thank you, Mr. Powers. Counsel?
May it please the court, Lyle Hoydu for Defendant Kuzdzal.
Could I just start with that last point? So Mejia says that Buford is not implicated in the circumstances in this case. And the circumstances in Mejias were essentially that a juror may have engaged in premature deliberations. If we read that in connection with CPL 270-35, which has a distinction between a juror who was grossly unqualified to serve and a juror who was engaged in misconduct of a substantial nature, I'm wondering why we're talking about Buford at all, and would like you to respond. It's sort of related to Judge Stein's question.
Well, in the Mejias case, they were parsing the word "we" that came in a note, so they're trying to figure out whether or
And
not,
pretext, both, right?
and yes, so the pretext in terms of coming to a conclusion, and then the use of the word "we," which would mean premature deliberations. But the distinction here is that, you know, that is, and it's similar sort of like what happened in the Third Department case was cited, that Matias, where the jurors were talking about something in general terms, but it was not specific to the defendant. In this case, they're disparaging the defendant, and they're specifically using the term scumbag when referencing him, which raises an obvious red flag. Now, there's potential there for bias and prejudice. Did it pre-exist? Possibly.
Well, would you agree that the statement would be more likely to indicate bias or prejudice or gross unqualifiedness if it had been made before any evidence was introduced as opposed to after all the evidence was introduced?
We don't know. On this record, we don't know. We are left to speculate. That's the problem throughout this, is that the prosecutor came up with a theory on the appeal as to what the judge did, but it's just a theory. It's based on speculation.
so that sends us back to the credibility question, right?
Right, exactly. Saying that it's, well, what the judge did was made a determination of credibility. Well, I don't read that in the record, and 3 judges from the Fourth Department didn't get
But
that
counsel,
conclusion.
so the judge clearly calls this person in and has essentially a hearing, talks to them, asks them questions, right? And then exercises discretion in saying, I'm not going to go any further. I'm having some trouble even on the other people's position. What are we going to send it back for? I mean, doesn't the conclusion itself, the action that the trial court takes, show you the exercise of discretion there? What would we send it back for?
Well, I agree. I don't think that that's a proper remedy to send it back.
Following along that, and I think what Judge Wilson's getting at, it seems to me in criminal trials particularly, you want to insulate the jury from outside forces. And we talk about a juror coming out or a court officer coming out who has some kind of access anyway to the jury room. But where you have a spectator, and in this case with some affiliation to the defendant, coming out and saying, I heard them call the defendant this derogatory term. I mean, and you have this hearing, hauling a juror in and then saying to that juror, did you call the defendant a scumbag? Don't you think that could have a negative effect itself on the juror's position in the case? I mean,
Well-
is that the rule we want? That when, you know, you have this type of allegation made, you're going to call a sitting juror into a courtroom and ask them if they did this? And they'll say no, okay. What happens? I mean, isn't that undermine all of the rules we have around the kind of sanctity of the jury? The judge makes a determination. Judge calls that witness. Judge puts that witness on the stand, questions the witness, and says, I'm not going any further with this. Exercise of discretion at that point.
Well, we do have the sanctity of the jury, but when we're talking about fundamental rights, there's nothing more fundamental than the right to a fair trial. And at the heart of that is the right to have an impartial jury.
But my point, I guess some of it at least, is protecting that impartial jury may mean not hauling them into a courtroom and accusing them of making this type of slur, and then saying, okay, I believe you're going to go back and now fairly deliberate, because they'll know where that's coming from.
Well, if you have two biased jurors against the defendant, and again, on this record, we don't know how deep their bias and prejudice goes because the judge never conducted the Buford inquiry, which is required. But if they exist, then that judge has a duty to remove them from that jury pool before they taint the entire panel.
It seems to me, doesn't the judge really have a duty at first to do exactly what the judge did here, which is call the complainant, for want of a better word, up, put them in the box, and say what happened, and then make an assessment on whether or not you're going to take that next very intrusive step, which may backfire in terms of a prejudice inside the jury room, by calling a sitting juror into the courtroom and asking them if they've committed misconduct.
But the judge, by following that type of a stepped approach, at the conclusion of making that inquiry of the first juror, or excuse me, the witness, then he's got to put his reasons on the record for what he's deciding to do next. In the case of the, I'm probably mispronouncing it, Matthias, where there was a witness who came out and said, hey, these two jurors, they're talking about the case, they shouldn't be doing that. What the judge determined was, after listening to what the witness overheard, it dealt with trials in general, it dealt with the boredom of being a juror. There was no prejudice shown against that specific, the parties in that particular case. So the judge deemed it unnecessary to go to the next step. That's not what we have.
Are you arguing that the judge's error, that it was that he did not place his findings on the record?
Pardon?
Are you arguing that the judge's error was that he did not place his findings on the record?
Well, that's part of what the Fourth Department found, is that the judge made two errors. One is that he did not do the probing and tactful inquiry that is required. And two is he did not place on the record the reasons for what his decision was.
I kind of read the requirement of placing reasons on the record a little bit differently. I see it as being required after the Buford inquiry if one is held. I mean, courts make decisions on issues all the time, and we as appellate judges hope and wish and encourage them to state their reasons on the record as much as possible so that we can intelligently review their decisions. However, that doesn't mean that every determination they make, every ruling they make has to be laid out on the record. And so I see this distinction in what Buford was really getting at. Would you respond to that?
I understand the distinction you're drawing, but I go back, unfortunately, in this case, on the record, I don't understand why the judge decided what he decided. Did the judge decide that the use of the term scumbag in and of itself is innocuous? I don't know. If that were the case, then let defense counsel know so that they know how to argue. Did the judge make a determination of credibility? If he did, let defense counsel know.
Certainly that would be preferred. My question is whether it's grounds for a reversal.
And following up on that, how does the appellate division actually get to a reversal when it says we are not making a substituted finding of credibility? I mean, it denies that it's making any findings of credibility one way or another. And I don't see how you get to the reversal unless they're in fact finding that the witness was credible, which they could have said. They could have said, we reviewed the record and we are making alternative findings of fact, but.
Yeah, there was not that finding at the appellate division.
Let me ask you this. Is it your position that a juror, after hearing all of the evidence in the case, the evidence is closed, who forms the opinion for himself or herself that the defendant is a scumbag, has acted improperly, or is it the communication of that view to a different juror that's improper, or both?
could be a whole slew of things, Your Honor.
No, but I'm asking, do you think both of those are improper?
I understand that jurors are going to sit there and they're going to form opinions and they're going to have words or ideas that come to their mind, and I'm not interested in parsing that. The problem is that when they're openly disparaging the defendant and they're using a term like scumbag, which can, you know, that's not a positive term under any circumstances, that I would want to know if those two jurors were overheard calling the defendant a scumbag during the initial jury selection, that would have been thoroughly vetted by the judge and the attorneys to make sure that there was not that bias. The problem I'm left with, again, is it goes back to, on this particular record, we don't know. And we're left to speculate. I see that my time is up.
Thank you, counsel. Counsel?
I just wanted to follow up on Judge Feinman's point. The appellate division did not make an alternative credibility finding, and I think that squarely takes us out of the realm of mixed question analysis. Unless there are any questions from the court, I'm prepared to stop there.
Thank you, counsel.